Does the Constitution impose any meaningful limit upon the legislature's ability to ban guns it doesn't like? The state claims its power here is nearly plenary. It argued that so long as it allows the possession of a single handgun, it can ban all the rest without even implicating the Second Amendment. And even if banning most handguns in America, including all new semi-automatic handguns since 2013, somehow implicates the Second Amendment, the state argues that so long as it has a reason to ban guns, the courts are obligated to defer not only to the legislature's assessment of what is best for society, but to the legislature's assessment of what is constitutional. First, let's make no mistake. The handgun roster law is a gun ban. It does not impose conditions or qualifications on the sale of arms. It delineates which arms can be acquired.
You see down the road that the number of available models, colors, et cetera, would be on a kind of a continuously shrinking continuum?
We don't see down the road. It's happening now. For example, right now, as we stand here today, there are only 744 models in the database, and of those, 307 are semi-automatics. But we looked at the numbers just last month. If you weed out the similars and the duplicates, there are really actually only 97 semi-automatic handgun models offered for sale today.
So so anyone, you can buy a handgun model, you just can't buy necessarily the model you might want, correct?
Well, sure. And if California told Ford Motor Company that it could only produce Model Ts, and Ford Motor Company said it's not in our interest to maintain the Model T production line anymore, then there would be no Fords in California.
This idea that the Unsafe Handgun Act is a handgun ban is misplaced and wrong. It's not a handgun ban. There are literally hundreds of different makes and models of handguns on the rosters today. My numbers agree with Council's number. I think last time I checked.
But Council, if all of a sudden the state of California decided to ban a book, it wouldn't be not a violation of the First Amendment just because we had libraries in California that were full of other books. So under your theory, could we simply ban all Lugers just because a Colt was available?
Well, it would depend on the reason that you would ban a particular model. Well,
if we just banned all Lugers, could we do that? But if we didn't ban Colts. And if California said no one may sell a Luger in California, would that get us through step one?
If it can be characterized as a condition and qualification.
Well, it clearly is a condition or qualification in the state's view, right?
I want to be careful because council has said that, well, if we can call anything a condition and qualification, why not just outlaw the sale of firearms? Well, that's not a condition and qualification. That's an outright prohibition. That's an elimination. That's what happened in Heller. So if you had an across-the-board elimination, it would not be a condition or qualification on the sale.
So let me go back to I think the answer to my question is easy, Council, but I can't get you to get there.
It's probably yes. Yes. The answer to get beyond step one alone, the answer to your question is probably yes.
You had indicated you pretty much agree with Pena's counsel's statement of this decline, and it's something like since 2013 the number of these rostered handguns has declined by just under 50%, 43.5 or something like that. That's a pretty dramatic figure of guns in terms of what is removed from the market in terms of for sale. How do you justify that? Because ultimately you don't have anybody manufacturing, for example, the micro-stamped guns. At some point, you're going to just slide right off that scale.
So why in the future, if from this point forward, no guns can be sold in California unless they have the MDM CLI microstamping? At some point, there won't be any inventory that doesn't meet that qualification, right?
Could I ask you a question on this idea that you can get another book? That seems to me just a little bit slippery of a difficult. And what occurs to me is you can close down a religion because next door there's another church. But there's fundamental constitutional values. So the idea that it's okay to limit guns because there's another gun you can get. It works pretty well here, but you took it to another constitutional right. There would be an upheaval if you said to people, we can limit this church and ban it because you can go to another church next door. Is that really the way we want to analyze this case?
No. My response in terms of books are not guns, that's in response to the analogy drawn by opposing counsel. And I think
I understand, and I'm asking you to comment on that part of it.
The key to that answer, I think, is what's the purpose of the Second Amendment, which is self-defense, specifically, the ability to possess a handgun in defense of hearth and home, which Heller puts it. So when you're looking at regulations, that's the ultimate interest that's always lurking in the background. When it comes to books, it's a much broader interest.
Yes, that's true.
When it comes to religion, it's a much broader interest but
it's very specific. You can go get a whole bunch of books, but if you really believe in one religion, it isn't satisfactory to go to another church. And that's the constitutional right that you can choose your religion.
Right. There's freedom we have freedom of religion. That gives us freedom of choice of religion.
Okay.
There's not freedom of choice when it comes to firearms. There's no constitutional right to buy whatever.
Isn't the right in the individual, not in the weapon itself? Isn't it the individual's right in the Second Amendment? There's no gun right. There's a right of individuals to have a gun.
I agree with the sentiment that the Second Amendment generally applies to people, not guns.
Yeah. But even when you do this is supposed to be a safety process that we've argued safety, but there's nothing about this stamping that goes to safety. That goes to the police being able to catch the bad guy and put him in jail.
Can you tell me about the MDM?
Yeah, so that's a magazine disconnect mechanism. It's a function that prevents a gun from firing when the magazine in the semi-automatic pistol is outside of the firearm.
So the gun could otherwise be fired if there was a bullet in the chamber.
If it didn't have the
MDM.
Correct.
If the purpose of the Second Amendment is to allow people to defend themselves, why would you place that restriction on them when the gun, even if they don't want the magazine in there for other reasons, the gun is at its most useful when it's got the bullet in the chamber. So now the gun can't be used at all.
Let's talk about over-inclusiveness. Obviously, this is a law that works to ban most handgun models in America. And if the state wins here today, they could ban all of them because, for whatever reason, there are no micro-stamping semi-automatics, and the micro-stamping rationale allows the prohibition of revolvers as well because revolvers don't eject. Well, the answer, Your Honor, is found in the state's handgun safety manual that teaches people not to rely on CLIs. I mean, as a basic common sense gun safety measure, we treat all guns as
not
loaded.
to rely on it at all, or not to rely on it exclusively.
Or to say that always assume a gun is loaded.
If you're always assuming the gun is loaded, then you're disregarding the CLI. This is an over-inclusive rule. It reaches far too many guns. It's under-inclusive in the sense that it has all these exemptions for all these special people who are allowed to introduce and obtain unsafe handguns. Your Honors, respectively, we would ask that the court reverse here. Thank you.
If you like our videos, follow, subscribe, like, and share.